Welcome to this Legal Aid New South Wales Law for Community Worker webinar on mortgage stress. My name is Bridget Barker and I am from the Community Legal Education branch of Legal Aid New South Wales. I'm joined today with Claire Curry, Mike Dunkley and Annabelle McConaughey from the Financial Rights Legal Centre. Good afternoon to you all. And also I'm joined with Nerida Walker from Legal Aid New South Wales Consumer Law Team. Welcome, everybody. Before we begin, I'd like to start by acknowledging the traditional owners of the lands from where we are broadcasting today. For me, that's the lands of the Widjabul-Waiable people of the Bundjalung Nation. We also pay our respects to the elders of the land, both past and present, and new leaders emerging, and extend that respect to other Aboriginal and Torres Strait Islander people attending the webinar today or watching the recording. The purpose of our webinar is to give you an understanding of mortgage stress and where to get help if you or your clients experience it. Today, we're looking at the spectrum of financial hardship, from someone temporarily having trouble paying their mortgage through to mortgage default and the legal process. We will look at what help financial counsellors provide and at what point a financial counsellor should refer their client for legal help. It's going to be an interactive webinar. We'll be looking at a case study and asking for your input. So we'll ask you to use the Q&A box to share your thoughts. During the webinar, we'll mostly use the term borrower when talking about the person experiencing financial hardship and mortgage stress. We'll refer to the bank or financial institution who lends money to the borrower as the lender. Okay, what we're going to cover in the webinar today: cost of living pressure. We'll look at financial counsellors, the credit law and financial hardship options, mortgage default, and repossession. And as I said, we have a case study. So we're going to look at getting help from a financial counsellor. So we're focusing on Ella's story for that. Just to let you know that today we want to get you thinking about what questions to ask your clients and when to refer them for legal advice. As I said, we won't be going into a huge amount of detail, so we recommend that you get yourself a copy of this resource, which has just been updated by both Financial Rights Legal Centre and Legal Aid New South Wales. You can download a copy from Legal Aid New South Wales Publications and Resources section of our website, and you can link to that from the homepage of the Legal Aid website. Did anyone on our panel wish to say anything more about that resource before I move on? Okay, thank you. Okay, Mike, what is mortgage stress?
Hi, I'm Mike. I'm financial counsellor at the Financial Rights Legal Centre. I work on the National Debt Helpline, so I work on the phones. I work on the chat. I also do some presentation CLE like this one. I do some media work. I attend bankruptcy hearings on a Thursday to help people who are unrepresented. And on top of all that, I do casework as well. And first, we'll just start with mortgage stress, and as we go through, I'll tell you some of my experiences about working on the National Debt Helpline, especially in regard to mortgages. And so for us, mortgage stress is when households finding it difficult to pay their bills, including their home loan repayments. There's lots of definitions, if you like, about what mortgage stress is. But a good rule of thumb is that if you're spending more than 30% of your pre-tax income on home loan repayments, then that's a pretty good flag for being in mortgage stress. And in the credit law terms that we will discuss in the webinar today, we're talking about financial hardship, we're talking about financial hardship options and people's rights to financial hardship in mortgages. Two reasons often for financial hardship. One, when they first took out the loan, the borrower could afford the loan, but circumstances have changed, including our famously high interest rates and ever high increasing interest rates. Or secondly, that the borrower couldn't afford to pay the loan in the first place. And so those two things result in two different options, two different discussions and different advices when we get those sorts of calls on the NDS, both for us as financial counsellors and for our legal friends as well. Change of circumstances, I think many of you will be familiar with, would be things like loss of employment, accidents or injuries, unexpected expenses coming along, and also some really normal things, which is what I'll talk about in the case study that we're going to do, like very normal things that happen to people that suddenly they find it unaffordable. If the borrower's in the second category, about they couldn't afford it in the first place, this is when they should get legal advice about it. There are laws about responsible lending, which we will go through, and this is the place where Nerida and Claire will be explaining things for you. Thanks. So sorry.
Oh, no, I was just going to ask you to explain about financial hardship and cost of living pressure. Thanks, Mike.
Oh, no worries. So the things that people experiencing in financial hardship, especially for the mortgages. So I will say that mortgages are one of the highest sort of categories of calls that we get. And often the people who call first-time callers to the National Debt Helpline and haven't found themselves in this sort of experience before. And of course, you can imagine when interest rates are going up and when something as important as a home that you're living in is suddenly imposing questions in people's minds about whether they can afford it or not. And then on top of that, with inflation, electricity costs, all the things that you've been experiencing both yourself and hearing about in the media, we get people who are quite distressed when they call. They're very confused about what they do, what they can do, and are looking for options to do with it. Thanks. Really good place to start is financial counselling help. We've been getting a lot of calls to the NDH, especially over the last, I'd say, 6 to 8 months. I feel like the NDH and financial counsellors are having a better profile in the community. And so this is a really great place to start first. So if you're referring to someone, I go for the National Debt Helpline first, 1-800-007-007. What we're doing on the call is first urgency. So first we've got to work out what the issue is and how urgent it is to deal with it, especially if there's some sort of threat of legal proceedings or some sort of default notice has been received or about to be received. That's what we're first doing in a triage sort of way. And then we're going through and explaining generally what financial hardship is, what their options might be. And then if necessary, we're referring them off to financial counsellors for detailed help. And so a financial counsellor, what we can do, we'll look at somebody's financial position in great detail. It's evidence-based, so we rely on evidence of people's income and their expenses. We put all that together. We look at all their loans and where they are at the moment, and then we try and go through a few options, which I'll talk about later. But when for your clients that are struggling with home loan repayments, I think the thing to say to them is that there is help available. Like there really is. There's more options available than what people think that they are. Certainly the larger lenders, like the banks, they have dedicated financial hardship teams who are well used to talking to people who are in the situation that your clients might find themselves in. And there are various things that can be done to help with their mortgage.
Thanks, Mike. So we've come to Ella's case study now. Ella is 30 years old and a mother with a new baby and a mortgage. Ella and her partner planned for Ella to take 12 months off work when they had their baby. So, Mike, what happened with Ella?
So Ella's based on a chat that I had with somebody, and what struck me about Ella's situation is how completely normal this sort of situation is. So Ella and her partner have a mortgage for their house, and she's worried about paying the house. She saved some money for mortgage repayments, including anticipating interest rate rises because her baby's on the way. So Ella and her partner had actually put money aside to pay for an expected single income that's happening here. All right. And what unfortunately happened with all the interest rate rises and the cost of living pressures that have happened, the savings that they put in place for the single income were rapidly dwindling. And basically, although she had negotiated a mortgage rate reduction just before maternity leave, the interest rate rises are basically, whatever they got as a reduction, it's over the top of that that's now. And Ella's presenting to me with a statement that says the mortgage is now 75% of her partner's income, which is crazy. The first thing I notice about this situation, as I said, it's completely normal. It is. We're in a situation now where mortgages require double incomes. And of course, having a baby, a joyous thing, and then suddenly going down to a single income should not leave you in a position where you're stressed about you're going to keep your home or pay for your home or whatever it might be. So I think this is audience participation time for all you out there. So what questions should we ask Ella? Just put them in the question and answer box.
I know we've got some financial counsellors in our audience today, so I'm hoping they'll have some great suggestions.
How are they coping with other financial commitments? Yep. So other debts. What other debts do they have? And Lee's put in, do they have any other debts? It's definitely a great question. Do they have any family support from their family? Thank you, Lee, again. When is Ella planning on going back to work? That's a great question. Thanks, Anne. Have they looked into childcare? There's a practical question, I think, dealing with the baby. Baby's quite young, though.
Have you spoken to your bank?
Have you spoken to your bank? Yes, number one. That's usually where I'm starting.
Is Ella able to increase her own income by gaining casual work and using family supports to care for the baby?
Mm-hmm. Is there any other sources of income?
So here we go. Let's look at your expenses.
Mm-hmm. Is there any room in the budget anywhere else? Certainly what a financial counsellor in a detailed appointment would be trying to get to the bottom of.
Shall we have a look at what you might suggest as well, Mike?
Thanks, Bridget. Yeah.
There's another one. How are you coping with mental health also?
Yes, that's a good one. As I said, a lot of people present to the National Debt Helpline and can be in great distress.
And do they need hardship on any other debts?
Part of the options, I think, of trying to address Ella's situation.
Okay.
Yeah, so we just here's a very prosaic one to start with. There's a mortgage in both names. If we're giving advice to one, we're also giving advice to the partner. It also tells us a bit where the liabilities might lay as well. Who is the lender? People have very in our experience, people have very different experiences with depending on who the lender is. So the banks are more tier 1, but once you start getting down to the tier 2 lenders who are perhaps haven't got the systems and not as sophisticated in dealing with these sort of situations. So it's important to us to know who the lender is, and we can give them some good advice about that. Is there any equity? So yeah, there's like an assumption, I think, in the Australian housing market that everybody has equity in their property as the property values rise. And what we're trying to determine here is how much equity is there, or if occasionally, it's very rare, except for investment properties, I think, of going into negative equity, but it does happen. But equity is important to how we address some of the advice we give and the obligations that the lender has about equity. Have you spoken to the bank? Yep. So we got that one. That's definitely. So it's often speaking to the bank, certainly with the tier 1, if you're talking about financial hardship, they're referring you pretty much immediately to their dedicated teams, especially for a mortgage. So we want to know what the bank has said about their situation, whether they've actually come up with any options themselves, and what's led somebody to come on to the NDH. Was it affordable prior? So this is back to a question that we were talking about at the beginning, whether the loan was actually affordable in the first place, or there are circumstances now that makes it unaffordable. Have you missed any payments, and are you in arrears? So this is important. This is important for me to start getting to the bottom of the urgency of the situation. So we have people who come to us who are worried about their situation, so they're not yet in arrears, or they think a situation is going to happen, like Ella's. So they think something's about to happen. But of course, we've got plenty of people who ring up and they have got some pretty significant arrears. And as arrears increase, then so does the risk of legal action against the property. And another one that came up is, yes, will you return, and when will you return to work to get back to this double income scenario, which hopefully makes it affordable.
Okay, so the next question for our audience is, what information and advice should we give Ella? Again, if you'll type into the Q&A box, that'd be great. Good point. Lee says it depends on her answers to those questions.
Yeah. So let's say that Ella's not going back to work for another 8 months. Probably got another 1 month left on her savings before something happens. The loan was affordable in the first place. And at the moment, there's no arrears. Have you spoken to the bank? No. I asked my partner about it, and he doesn't think we should speak to the bank. We shouldn't tell them just in case they do something to us.
So yeah, Lee suggested provide her with her options, including speaking to the bank.
Mm-hmm. What sort of options do you think might be available for a mortgage financial hardship?
As it is a joint loan, we need to have the partner on board.
Yes, I think, well, definitely in a practical sense, 100%. And certainly you've got 2 incomes, well, 1 income at the moment, but yeah, 2 of them contributing to the mortgage. That's a joint loan. For an application for financial hardship, you don't need the other person's permission to do it. If it's joint, you only need 1. Talk to a financial counsellor, definitely. Centrelink, yep, to see if there's some other, at least, well, certainly won't be to pay the mortgage, but if there's some sort of assistance that's available for Centrelink to help out with the income.
Applying for financial hardship plans such as reduced payments.
Yes, yep, definitely.
Yeah, a few people have suggested that.
Refinance your loan, cover
yeah.
interest only. Yep, definitely.
Okay, let's see what you had as well, Mike, to suggest.
So the way I approach a mortgage, and especially compared to other loans. So first up, I would be telling Ella, reassuring her and explaining that there are options available for financial hardship, and that it's okay to talk to the bank about it, because the bank will have teams dedicated for financial hardship. They'll be well versed in the laws associated with it. They'll listen to your situation, and they will do their best. One of the big four banks will do their best to work with you to try and solve this information. The bank does not want to take you home. It really doesn't. It has no interest in doing it. It doesn't make any money out of it. They make money about keeping you in a loan. They don't take money out of taking your house off you. It makes no business sense for them, and they have people who are available to help. The credit law. So I would start talking about financial hardship under the credit laws, that have rights available for it, and this is what Claire and Nerida will go through in detail later. So there are options available under the credit laws. You have rights and also to complain if they're not treating you reasonably as well, both internally and externally. Generally speaking, when we're talking about options for unsecured loans, they can be short-term or long-term. So short-term might be put a pause on loan repayments, or maybe a reduced repayment for a little bit of time. More long-term for unsecured, we're talking about trying to get on a repayment plan, especially trying to get that interest to stop and then repay it over something like 24 or 36 months. Mortgages are all short-term options. So there's no such thing as the interest stopping on your mortgage or a long-term repayment plan. So it's all about pausing payments or reducing payments for a period of time. So secured debt, and especially housing, is more difficult to negotiate, because the options are not as available. The bank also, from their point of view, so whenever I'm talking to my clients about what's going on, you also have to put yourself in the shoes of the other party. You do, to get an understanding of where they're coming from, so that when you're talking to them, you can try and get the best outcome for your client, or if your client's talking to them directly. And for a bank has a few obligations about financial hardship, and about not putting your client into a worse position than where they are in the first place by giving them financial hardship. Basically, that manifests itself as eating up all the equity. So if you think about, if that sort of obligation wasn't there, which might manifest itself as a regulation, or let's say a duty of care, then if that wasn't there as some sort of protection, the bank would happily just take all your equity away, make the money out of that with the interest, and then sell your house, you see. But that's not what happened. So what they want to do is help preserve that equity as much as possible by giving financial hardship, not putting you into a worse position. And that's why these sort of options are more short-term. Now, as I mentioned, the rights of your client under the credit laws, consumer credit laws in Australia, they have a right to apply for financial hardship in the circumstances that they are. And as part of that, they ask for the options. After that, if they're being treated unreasonably, they certainly have an option to complain internally with the lender, and then an option to go to AFCA, the Ombudsman. But as I said, Claire and Nerida will explain those things in a little bit more detail later.
Mike, would you be discussing superannuation in the mix at this point?
Probably not for Ella's situation. So super is available to pay the mortgage, but it's really only available right at the pointy end of possession. Yep. So not at the start here. So right at the pointy end of possession when it's threatening to do it, that seems to be the time when the ATO might release it for mortgage hardship.
Okay. All right. We'll move on to sorry, I'm a bit slow in bringing this up because you have spoken about payment arrangements.
Mm-hmm. They make a decision to sell the home, best to make that decision as early as possible to preserve the equity. If you need, and then as people have mentioned in the chat box here, get some help maybe to pay it, a boarder, surplus, renting it out. And we did talk about early release of superannuation, but a bit early for Ella's case, I think, more at the pointy end. Thanks, Bridget.
All right. So hardship agreement. Will you run through that for us, Mike?
Sure. So when you apply for hardship, what you want to do is get any arrangement that you make in writing. This arrangement doesn't need to be, it will be reviewed. So typically for banks, when it goes into a hardship arrangement for a mortgage, we're talking something along the region of 2 or 3 months. That doesn't mean it'll necessarily finish at the 3-month mark, depending on the circumstances, but often they'll say, come back to us in a couple of months or 3 months and tell us where you're up to with the situation, and then we'll look at some sort of next steps then, including extension of the hardship. The one the bank is trying to consider, and the one thing that they are most worried about is this loan going to be affordable in the future? That's what they're most concerned about. And so if we've got some arrears, which will accrue, even if you don't have some in the first place, by having a payment pause or a reduced payment at the end of, say, 3 months, there will be arrears there. Then the question will be, what's the plan to address those arrears? And basically, if you're back to a situation you can afford it, can there be increased payments in order to do it? The banks can add the arrears to the mortgage, known as capitalisation of the arrears. That does of itself, certainly over a period of, let's say, if there's 20 years to go on a mortgage, significantly increase the amount that's owed and will increase the payments that are due monthly as well. So there's a bit of, you know, positive and negative about putting it on arrears onto the mortgage, even though it might address a certain spike in payments at a particular time. This is more towards, I think, where it's gone through into some sort of process that's there, where if you're coming to some sort of arrangement, you want to be asking about, is there any legal costs or default fees that can be there that we can actually get taken off? If there is a statement of claim that's come out, and I'll let Claire and Nerida talk through to this process, so it's a little bit more clear. Definitely, when you get to that point of financial hardship and it's been accepted, you want to make sure that any legal proceedings that have started have now finished and that is in writing.
Thank you, Mike. I'll now ask Nerida to speak to you all about the credit law and your rights to seek loan variation.
Thank you, Bridget. My name's Nerida Walker. I'm a solicitor at Legal Aid New South Wales in the consumer law team. And I'm basically going to reiterate what Mike just said, but it doesn't hurt to go through it again. The National Credit Code, which is part of the credit law along with the National Consumer Credit Protection Act. So the code helps people in financial hardship by giving a borrower the right to apply to their lender for a variation to their loan repayments due to financial hardship. More often than not, it is a temporary variation. A borrower can call or write to their lender straight away requesting a repayment arrangement. They must be having all will have trouble making their loan repayments because of any reasonable cause, such as illness, family breakdown, or unemployment. So, a borrower may request to extend the term of their contract and reduce their payments temporarily, or extend the term of their contract and delay repayments for a fixed period of time, or delay repayments for a set period without extending the term of their loan contract. As Mike said, the borrower needs to work out why they are having trouble making repayments and what they want to offer as an affordable repayment arrangement. They must be able to make that repayment each month. So a borrower should not offer to make a repayment that they cannot afford. And this is where a solicitor would work in concert with a financial counsellor to work out a realistic payment arrangement, or whether a realistic payment arrangement is even achievable. A suggestion as a guide: a repayment offer should not be more than 50 to 60% of a borrower's income, as they need to make sure they have enough money left for essentials, not least of which is food. Now, the law requires the lender to respond to an application for a financial hardship variation in writing within 21 days. If the lender does not agree to the change requested by the borrower, the lender must notify the borrower of the borrower's right to lodge a complaint about the lender's decision with the Australian Financial Complaints Authority, which is sometimes abbreviated to AFCA, AFCA. And the lender must provide their reasons for refusing the hardship application. More often than not, it is the lender saying that they think it's unaffordable. Now, all enforcement by the lender is stopped until 14 days after the lender's refusal of the borrower's request for a change on the grounds of hardship. The borrower can also lodge a complaint with AFCA, and we're going to detail that in the next slide. The right to make a repayment arrangement, so a hardship variation, depends on where the lender is up to in the process to take possession of a borrower's home. The earlier in the process a complaint is lodged, the better chance the borrower has of making a suitable arrangement that can help them from going into arrears and defaulting on the loan. Now, don't forget, a borrower can also make hardship arrangements with other creditors, such as credit card, and with energy providers as well. The lender does not have to agree to the change a borrower asks for if they will not reasonably be able to repay the loan if the change is granted. And that comes back to one of the most common reasons that a lender may refuse a hardship variation application from a borrower. Here we go. The Australian Financial Complaints Authority, or AFCA. All home loan lenders must be members of the approved free complaint resolution scheme, AFCA. It's essential that you remember that AFCA is free for consumers. In fact, all lenders who give consumer credit loans, such as credit cards and personal loans, or loans for investment in residential property, not commercial, must be members of AFCA. Using the complaint resolution scheme, AFCA, is the best way for a borrower to resolve a financial hardship complaint with a lender. Under AFCA's rules, the lender cannot start or continue legal action to enforce the debt while a matter is being considered by AFCA. In most instances, unless it is urgent, if a borrower is not happy with the decision made by their lender, they should ask for that decision to be reviewed by the lender. So all lenders have an internal dispute resolution, abbreviated to IDR, process. A borrower can find the name and contact details of the IDR team for their lender by searching for the lender on the AFCA website under Find a Member. Sometimes an IDR complaint will resolve the matter and an agreement can be achieved between the lender and the borrower. And as Mike said, it is essential that the borrower confirms that in writing with their lender. If, however, the IDR, internal dispute resolution process, does not resolve the dispute in a borrower's favour, or they're dissatisfied with the outcome of IDR, the borrower should then lodge a complaint with AFCA directly. The quickest way to do this is online at the AFCA website, and there's the address of the AFCA website there. Thank you.
Thanks very much, Nerida. Claire, at what point should people consider selling the home?
That's a really good question, Nerida. Bridget, sorry. Thank you for asking. So hardship variations required under the credit code are generally sort of short term. And what we need to be looking at is the financial hardship temporary or long term? So most lenders will agree to a 3 to 6 month arrangement and will often consider a further 3 to 6 month extension. If the borrower is already in considerable arrears and they don't realistically know when or if they will be able to get back on track, then they would probably have to think about selling their home. So making a decision about whether to sell a home is obviously very difficult, and it is most difficult when either the borrower is unemployed and trying to get back into gainful employment, or the borrower is ill and they are in the process of trying to get well, but they obviously don't know when they will be sufficiently recovered, or if they're waiting for some type of compensation payout. So in these situations, a borrower is hoping that they can make the loan repayment soon, but they're not certain of when this will happen. The difficulty is that as time goes on, things are going to obviously get worse and they will get further and further behind on the loan repayments, and they will incur extra interest, fees and charges. So in these circumstances, it is recommended that a borrower try and make a repayment arrangement with the lender for up to 6 months if they can, so that they don't have to sort of keep going back and asking. And then if by the end of the 6-month period, they can, if they still cannot make the loan repayments, they should put their home perhaps on the market. They can go back to the lender and negotiate a further arrangement on the basis that they are selling their home, and they will need time to do that. So a borrower should consider selling their home when they can't afford the loan repayments and they will be unable to afford the loan repayments for some time to come. A borrower needs to make this decision as early as possible, because it is better to sell their home themselves rather than have the lender sell the home for them. a borrower is always more likely to get a better sale price for the home, and by selling it themselves, they would avoid lots of legal costs by being able to do that themselves. So when does a borrower have to decide? Again, as early as possible and preferably before the lender commences any legal proceedings. It is never too late to ask for time to sell, but the lender is less likely to agree later in the enforcement process, and when enforcement costs are then added to the loan as the legal proceedings progress.
Thank you, Claire. We thought also that we should consider the bank's point of view in this situation.
So if your clients are struggling with their loan repayments, there is help available. As I've said previously, the earlier they get help, the more options they will have. Often people think that putting their head in the sand is going to solve things, but it doesn't. It just makes things worse. Banks have dedicated customer support teams to assist customers. That these people look at changing the terms of their loan or temporarily defer or reduce repayments, or you can look at requesting an interest rate reduction. These dedicated customer support teams, they will talk to customers or borrowers about options and managing their budget. They may allow borrowers to change the terms of their loan. As I've said, look at deferments and so forth. If they don't allow customers to make these changes, they need to explain why in writing and give customers details about where they can complain. If customers can keep making repayments, even if they're very small nominal amounts, to help keep the cost of the mortgage down, it's also a sign of good faith to make whatever payments they can afford. So the banks do have these dedicated mortgage hardship teams that are there to try and assist.
Thank you, Claire. And so what about if the borrower, the homeowner, does nothing?
Well, that's, we get a lot of people that do exactly that. So every mortgage gives the lender the right to take possession of the home and sell it if the borrower is not making payments on the loan. There's obviously a series of steps that they need to follow before they can exercise their power of sale under the terms of the mortgage. I will go through those steps. So what happens when a borrower defaults on their payments? So there's obviously the missed payment, and then sometimes they will then sort of send out a default notice straight away. The default notice gives a lender written notice that there has been a default, and they will give them 31 days to pay. During that time, you can negotiate a hardship and extend time for the default notice, and lodge in IDR or EDR if it's rejected.
We have got more slides on this in greater detail also.
We do. It's it's like a little brief summary of the process in a snapshot, if you like.
Just letting the audience know that there is a bit more detail to come as well.
Yes, thank you. So then if the default notice expires, so if the arrears aren't paid and there's no sort of variation that's agreed to, the bank can then call up the whole amount due under the loan. It's not just the arrears that are then owing. They can then issue a statement of claim that gives the borrower 28 days to file a defence or lodge a complaint with AFCA. If none of those things are done, the lender can then issue a notice to vacate. And we'll talk about that in a little bit more detail. So that's just a brief outline of the steps for what occurs after a payment is missed. When clients borrow money to buy a home, the lender takes a mortgage over the house as security. If they do not keep to their contract with the lender, they can take the home from them and sell it. This is called repossession. If the lender is threatening repossession, clients should get legal advice. They can contact the National Debt Hotline, Financial Rights Legal Centre, Legal Aid. There are lots of different places for people to call and get legal advice. So the most common defaults are missing repayments. A non-monetary default is if the property is not insured. So often that's a requirement. The lender sends the client a default notice. It says that they've got 30 days to fix the default and get the loan back up to date and keep any other payments that become due during the 30 days. This notice will usually say it is a combined notice under Section 88, Schedule 1 of the National Consumer Credit Protection Act, and Section 57(2)(b) of the Real Property Act in New South Wales. If the client has not fixed the default after the 30 days, the entire loan becomes due, so not just the missed payments. If the home is vacant, the lender can go onto the property and change the lock straight away. They can then sell the property. People in that position should get urgent legal advice. If the home is not vacant, then the lender goes to court. They send you the statement of claim asking for possession. They'll often go for debt and possession. There may also be a notice to occupier on top of the statement of claim for those circumstances in which the property is rented to tenants. The client or the borrower has 28 days to respond to the statement of claim. And if they don't respond, the court can give the lender an order for possession of the home. People often think that they need to attend like a court appearance for there to be a judgment. That's not the case. The lender will simply file some documents with the court and obtain that judgment. The court may also give a judgment for the whole loan balance plus legal and court costs. The lender will then get the sheriff to send what's called a notice to vacate. This will have a date and time when the sheriff will come out to the property. They will change the locks to the home, and then they will give the keys to the lender. The lender can then go through the process of selling the home. They will ordinarily hire a real estate agent. They will advertise the property and they will sell it at public auction. If the sale price is enough to pay off the client's mortgage and any legal and sale costs, then the lender or the client gets any money that's left over. Often that's not the case. Often the sale price is not enough to cover what is owed, and then there is a shortfall, and the lender, sorry, the borrower or the client will still owe the money to the lender, so they will be chased for the shortfall. Your client should also get legal advice urgently if they are being threatened with bankruptcy for any debt, especially strata debts. They're very popular at the moment. Or if they have received any bankruptcy notices or creditors' petitions. Bankruptcy is a way other creditors can force the sale of a home.
So I think the main message there is that you need to do something.
Yes, don't just put your head in the sand. Don't do nothing.
Thank you, Claire.
Thanks.
So Mike, we'll go back to Ella now. And we've got a bit of a change to her situation to try and draw out some other issues. I think you're on mute at the moment.
Again, some more audience participation, and given Claire's lengthy explanation of all these sorts of steps that are in here, I'll be expecting you guys will know the answer to them. So let's just go through maybe some other questions that we would ask, what sort of information or advice or recommendations we would make. So again, into the question and answer box. So Ella's told us that she's missed 2 months worth of payments. Is there anything else that we need to know? We might change our answers a bit.
The question that Lee suggests is, did you speak to the bank?
Yeah, I mean, the bank's not hanging around, so they'd be trying to get in contact with Ella and or her partner. So we definitely want to know what's going on with what they're thinking.
And did you enter any hardship arrangement?
Mm-hmm. Yep, good one. Are they already in hardship?
Or has she asked for a hardship arrangement?
I should say already in a hardship variation. Yep. Thanks. Okay, what about if Ella and her partner have received a default notice, Section 88 default notice? What are we doing then? Panic's not the answer, by the way.
Oh, another question was, has she spoken to Strata, if that's applicable?
Yeah. Strata can be have a bit of experience with Strata at the bankruptcy hearings. They are, as a collective, the number one people who start a creditor's petition. The second, I'm sure you can guess, is the ATO, especially lately. But Strata is one of the big ones, and they can be quite difficult to deal with and negotiate with. Very important your clients don't get too far behind on their Strata. Keep up to date with them. Contact the bank about the default notice. I think I'd be starting to talk about AFCA. That's what I'd be thinking. Yeah.
Ask when she received it, the default notice.
When she received the default notice, yep. So we've got 30 days. So often people are ringing up on the NDH and yeah, there's only a few days to go. All right. So then we're talking about urgent sort of intervention. Thanks. And what about the statement of claim? We get to this point here. To me, this is when the bank is looking to take possession. So we're in a quite urgent situation. Legal advice, yep. One. Super options, yep. I think super options are starting to come into play right now. Yep, and legal. So we're talking to Nerida, Legal Aid. We're talking to Claire at the Financial Rights Legal Centre or even me if you like. Legal's a good place to go. And again, we've only got 28 days to address this thing. And so, very unlikely these arrears, if they're making a statement of claim that's causing this thing, it's going to be repaid in 28 days. So we're trying to do some sort of urgent intervention. How about a notice? Oh, considering selling a home to talk to the bank. Yes, buying some time. Often, especially in strata, we're right at the pointy end of bankruptcy. So you can imagine how few the options are at the bankruptcy stage when someone's trying to make you bankrupt, and it's been going on for considerable time, often years. Often the only option is to preserve that equity and get time to sell the place themselves. Usually very successful, at least at bankruptcy hearing, getting adjournments to buy time for people to sell it themselves. Quite successful at that. Notice to vacate. Yeah, I'm definitely going legal on that one. And being made bankrupt. Yep. Again, Financial Rights Legal Centre, Legal Aid, and someone like me who goes to bankruptcy hearings. I can give you lots of advice. We've got a Financial Rights Legal Centre has a dedicated casework line that will give you the number at the end of it if you're not already familiar with it. And we certainly on the NDH at the Legal Centre enjoy picking up your calls from the caseworker line so we can workshop the issue together and get to a good outcome for your client. All right, I think that's it, Bridget.
Yeah, so any additional or different questions that we would ask?
No, I think the ones that come up in the chat were all good. So we're talking about timeframes. Yeah, more than anything else. We've got limitations. We've got things that need to be done quite quickly. And we're talking about, well, what are the circumstances and what discussions have you actually had with the other party?
Great. Thanks very much, Mike. So Claire will now go into a little bit more detail about the matters that she's discussed already. So we'll look firstly at default notices. Thank you, Claire.
Thanks. So we've already touched on this briefly, but the lender must provide the borrower with a default notice under Section 88 of the credit law before they can take any further steps to enforce the loan. This default notice gives your client at least 30 days to fix the default. So there's the mispayment. Once you have the mispayment, a default notice can be sent out at any time. And then at that point, you can try and negotiate a hardship variation and lodge in either internal dispute resolution. And then if that doesn't go the way that you were hoping, you can then lodge in AFCA. So they're essentially the two options. A lender with a default notice, the lender gives the written notice. It's a minimum of 30 days to pay, and then you can negotiate. So if there is the default and the usual payments, repayments are paid, then the contract goes back to normal and the lender cannot commence legal action. If that's not the case, the lender can make the whole loan repayable. So it's not just the arrears that are owing. We might just move on to statement of claim. If the borrower hasn't responded to the default notice, the lender can start a case. It's in the Supreme Court. The lender can claim for the arrears, so the amount the borrower is behind in the repayments on the loan, and or for debt or for possession of the borrower's home, or both. So they can go for debt and possession. The document that starts this is the statement of claim. The lender must have the statement of claim served on the borrower. That means that they must have someone personally hand it to the borrower. The borrower then has 28 days from the date of service of the statement of claim to file a defence or lodge a complaint with the Australian Financial Complaints Authority. The borrower should get legal advice about whether they have a defence, and they should also look at lodging a hardship complaint in AFCA as soon as possible. If the borrower lodges in AFCA, the lender cannot take any further steps in court until the AFCA complaint is finalised. So in a lot of respects, it buys them essentially some more time. If the borrower does nothing or files a defence and it's thrown out because it's not a defence or the defence is unsuccessful, the lender will get what's called a court judgment, essentially, and it will more often than not, be for debt and for possession of the property. So just moving on to a court judgment. So if the borrower does not file a defence at all or lodge a complaint in AFCA, the lender can ask the court to make an order that they get possession of the property. Once judgment has been entered, a borrower cannot make a complaint to AFCA or get financial hardship assistance from AFCA to try and vary that loan. So in terms of what happens then, a borrower can still try to negotiate a repayment arrangement with the lender after they have judgment. If the lender agrees to a repayment arrangement, the borrower must make sure that they get it confirmed in writing and that they will hold off enforcement action. If the borrower makes a repayment arrangement after the court has granted judgment and they miss a payment, the lender can apply immediately to get possession of their home, even if they are a day late, even if they're just, a few dollars short. And obviously, once the lender has a judgment, they're probably less inclined to, or be more difficult to negotiate with them. Just moving on. Thanks, Bridget. Once judgment has been made, the sheriff, who is an officer, enforces the court's orders, and they will serve the notice to vacate on the borrower, and the borrower will be given often not just to the borrower but also to the occupier if there is one, so if the property is tenanted, and the sheriff will give the notice, and the notice gives a minimum of 30 days in the first instance. So yeah, when that's first served, if the borrower does nothing, the sheriff will come to the home and evict whoever is inside, and they will change the locks. And what we often tell people is that they need to ensure that they have taken all their belongings and made arrangements for any animals that are at the property, because once the locks are changed, any access thereafter will need to be supervised, and that will add to the costs. So at this stage, your client can make an application for what's called a stay. They could try and negotiate a set aside. They could look at lodging in AFCA. AFCA at this stage has sort of very limited powers to be able to do things. So they can keep negotiating with the lender, but it's often very difficult at this late stage. If they don't agree that they owe the debt, it's sort of too late to dispute the judgment. If you are looking at lodging in AFCA, it can only be for time to sell, refinance, or move out. They should do this as early as possible and get legal advice. Lodging in AFCA does not automatically stop the eviction, and AFCA may not be able to help if there is not enough time before the eviction date. So if it's a few days before the eviction, then there's, from our perspective, no real point going to AFCA, and applying to the court for what is called an urgent stay would be the preferable way to go. You can ask the court for time to sell, refinance, or move, and we would assist in doing this by making an application for a stay on the notice to vacate, which brings us to our next slide. So essentially, a stay means that the eviction from the borrower's home will be placed on hold until a later date or until the stay is lifted. The borrower may be able to apply for an extension of time for them to move out of the house or stay all action, depending on their circumstances. They must get urgent legal advice. So if we're applying to the court for a stay, you need to be aware that it is difficult to get like a long-term stay of an eviction, and the process is mainly used to get a stay for a few weeks, or less commonly a few months. The borrower will need to lodge court documents asking for a stay, and a sworn statement, which is called an affidavit, that states why they are asking for a stay, and any documents that support their request. So, for example, if they are selling their home or they want time to sell the home, they would need to show that they have a contract for sale and have listed the property with a real estate agent, or they may provide medical reports if they are saying they need more time to move out due to illness or injury. The duty registrar at the Supreme Court can help clients with court process, but they cannot give legal advice, and that's why you should give us a call or legal aid. Clients hopefully should not leave this to the last minute, but unfortunately we see that a lot of people do, because it takes time to put the court forms together, and there is a fee or what we often tell people to do is to apply for the fee to be waived or postponed, and that's another form that needs to be completed. If the stay is not granted, the client will need to be prepared to leave the home on the eviction date. So an urgent stay is usually granted for up to 7 days, and then the matter will go back to court within those 7 days, and the client will need to show evidence and reasons for why they need to be granted a further stay and how long they will need. The lender or their lawyer may argue that the court should not give you more time. We may be able to negotiate with them. The client needs to act quickly, so they don't need to keep going back to the court to ask for more stays. Every time a client goes back to court, it gets harder with each stay application. And so then you would need very good reasons and further evidence for the court to provide further time. The lender will add their legal costs onto the mortgage because the loan contract says that they can. The client will need to provide evidence to the court to explain why they should give more time. So if they're close to selling the house, as I've said earlier, they'll need to include a signed real estate agent contract, copies of advertising or the contract for sale. If they are just going to get a refinance arrangement approved, what we will ordinarily try and include is a copy of their loan application or a letter on their broker or lender's letterhead explaining where their application is at in that process. If moving will cause the client severe personal hardship, we will need to include medical evidence or evidence of being unable to find alternative rental accommodation. The court will often grant an urgent stay without this evidence and without the lender there to make counter arguments. So that's the initial urgent stay application. But when the matter goes back to court, they expect you to provide further evidence. The lender can argue why you should not be given more time. As these are court processes, the lender will usually be adding more and more of their legal fees to the debt, and for the time that their lawyers have to attend and respond to the application.
Thanks very much, Claire, for all that detailed information. So everybody, that's the end of the information that we're sharing. Just to point out to you the websites and phone numbers where people can get help. So there's the LawAccess number there. That's the entryway into legal aid. There's the National Debt Helpline. There's a website address there, ndh.org.au. And the National Debt Helpline number is 1800 007 007. The LawAccess number is 1300 888 529. And the website for the Financial Rights Legal Centre is www.financialrights.org.au. And then there's the Credit and Debt Legal Advice line for New South Wales, which is 1800 844 949. So thank you for your participation. And now we've got a panel available to answer any questions that you might have, either arising from the scenario of Ella's situation, or any other questions you might have about financial hardship and mortgage stress. Looks like we've got about 13 minutes, so feel free to put any questions to the panel while we've got everybody here with us.
Bridget, can I just quickly hop in with one comment? Is that okay?
Oh, absolutely. Thank you, Nerida.
Good. I just wanted to remind people that almost always it's the case that a lender will commence proceedings in court to get a judgment so that they can get a writ to send the sheriff round to take possession of a property, but they don't have to. They don't have to. They almost always do, because the sheriff can physically move someone out of the property if they don't. But people, particularly lawyers and financial counsellors, should be aware that rarely, but sometimes, a lender will try self-help, and they may come round and say, we've issued the default notice, out you get. So just be aware of that. They're not legally required to file a statement of claim in order to take possession of the property. And I'll also, I know someone had a question beforehand about financial hardship in the context of a joint loan and domestic and family violence.
Thank you, Nerida. Yes, so
Yes.
yeah, they were interested in financial hardship after separation, where there is domestic violence and prior to a property settlement.
Yeah, so if that person is still on the webinar, because joint mortgages, the borrowers are jointly and severally liable, either party can lodge a hardship application, and they can make an IDR complaint to the bank, and then they can also go to AFCA, and there are protections around making sure that information beyond what is absolutely necessary isn't shared with the other party, particularly in the context of domestic and family violence. And I urge people, both lawyers and financial counsellors, to have a look at AFCA's approach paper, it's called, about joint accounts and family violence. It's designed for consumers, financial counsellors and lawyers to read, and you'll find that on AFCA's website, and it goes through all those scenarios. But essentially, there's no difficulty with one or both parties lodging separate hardship applications post-separation, pre-property settlement in the context of domestic and family violence.
Thank you very much, Nerida.
No problem.
It looks like we've provided way too much information because people don't have any questions for us at this point in time. Of course, everybody, you can always send a question through to CLE at legalaid.nsw.gov.au, and we can facilitate getting some information for you. But if people don't have any burning questions, then we might just finish up early and give everyone an early mark to lunch. So I'd like to say a really big thank you to Nerida from Legal Aid's consumer law team, and to Claire, Mike and Annabelle from Financial Rights Legal Centre for putting so much effort into presenting this information to you today. And we'll say a good afternoon and thank everybody for joining us. So bye, everybody.
Thank you.
Thanks.